If you've been injured in a bus accident or a mass transit accident, the entities that can be held responsible depends upon exactly what happened to you at that moment. So could it be operator error? And then if it's the operator, it's also their employer who is vicariously liable for the conduct of their operator. It could be a product liability case. It could be a negligent maintenance case. It could be a highway design case. There could be any number of potential defendants depending upon exactly what happened. If you have a claim specific to a public transportation entity, right now as it stands, and there is movement underway to address this and to remedy this, but there are different obstacles to recovery because with regard to state and governmental entities, there are caps in what you can recover, and then also there are limitations on what you can sue those entities for, and you have to have a certain threshold of injury. So there are statutes that are in place. Some call the Political Subdivision Tort Claims Act, some the Sovereign Immunity Act. There are statutes in place that insulate these entities depending upon the defendant and the type of accident that occurs. If you've been involved in an accident case that involves a governmental vehicle, if it involves a traditional SEPTA bus or a school bus, some of these buses are operated by private companies and you might not know that. So we have to evaluate that. As soon as we are contacted, we will write to the appropriate entities, we'll do our research and our investigation to determine whether or not a third-party operator was involved. If one was not involved and it's a governmental entity, they will try to take advantage of immunity statutes that put caps on the amount that you can recover in those cases, even though there is movement underway to either eliminate those caps or to try to increase them.